Hey everyone, welcome back. So years after conflicting federal court rulings, the fight over freight broker liability is now in front of a new audience, the U.S. Supreme Court and its 9 justices. The case is Montgomery versus Caribe, and it centers on whether freight brokers can be held liable under state negligence laws for crashes involving the motor carrier that they hired. Now, the respondent is C.H. Robinson, and they're one of the largest 3PLs in North America. The appeal was brought by truck driver Sean Montgomery, who was struck and injured in December of 2017 by a truck operated by Caribe Transportation. Now, according to FMCSA records, Caribe was active at the time with just one power unit. C.H. Robinson hired Caribe to move the load, and after the crash, both the carrier and the broker were sued by Montgomery. C.H. Robinson argued that it should not be held liable, and so far, the courts have agreed. Both the U.S. District Court for the Southern District of Illinois and the 7th Circuit Court of Appeals have both ruled in favor of C.H. Robinson, holding that federal law preempts state negligence claims against brokers related to carrier selection. But other federal circuits have ruled differently in similar cases, allowing the claims against brokers to proceed. That split between circuits is what led the Supreme Court to take up the case. Last week, C.H. Robinson filed its response brief with the court, replying to arguments already submitted by Montgomery and his supporters. Now, the arguments themselves, they're not new, but they are being weighed at the highest level. At the center of the dispute is the Federal Aviation Administration Authorization Act, or F4A. The first part of F4A blocks states from regulating transportation prices, routes, or services. Now, the second part of the F4A is known what is called the safety exemption, which allows certain state actions if they involve safety and which are with the respect to motor vehicles. Now, the entire case rests on what that phrase actually means and how the Supreme Court is going to interpret it. Courts that have allowed broker liability claims have concluded that with respect to motor vehicles includes brokers who hire those vehicles. Courts siding with brokers, including the 7th Circuit in Montgomery, have concluded that the exemption is much narrower and applies to laws with a direct connection to motor vehicles themselves, not commercial decisions like selecting a carrier. C.H. Robinson's brief leans heavily into that interpretation. The brief also points to how Congress structured liability and insurance requirements across the entire transportation industry. Motor carriers are required by federal law to carry liability insurance to cover personal injury claims. Airlines face similar requirements. Brokers, however, do not. According to C.H. Robinson, that omission matters. The argument is straightforward. If Congress intended for brokers to face personal injury liability, it would have required them to carry insurance capable of covering those judgments. The company also highlights that brokers are explicitly mentioned elsewhere in the F4A, including provisions governing intrastate rates and services, but are notably absent from the safety exemption itself. Throughout federal transportation law, Robinson argues Congress regulates motor carriers with respect to safety without mentioning brokers at all. And if Congress wants to change that, Robinson says, it can do so directly. Now, the brief argues stakeholders are free to push Congress to revisit the balance struck between safety and economic efficiency, or to urge states to raise the minimum carrier insurance levels, something that hasn't changed at the federal level since the Motor Carrier Act of 1980. Though some states like New Jersey have increased it on their own. What Robinson strongly opposes is what it calls a 50-state patchwork of regulation by jury verdict. If negligence claims like Montgomery's are allowed to proceed, the company warns, brokers and shippers would be forced to select carriers based on differing state standards, increasing compliance costs, limiting carrier access to freight, and creating new barriers to entry to the market, especially for smaller carriers and owner-operators. The legal teams involved heavily underscore how high the stakes are here. C.H. Robinson's Supreme Court brief includes Theodore J. Botris of Gibson, Dunn, and Crozier, a veteran Supreme Court litigator, alongside longtime counsel and attorneys from Thompson Coburn. And Montgomery's team added former U.S. Solicitor General Paul Clement, who served under President George W. Bush. Circle your calendar for March 4th. That's when the Supreme Court will hear arguments that could redefine broker liability across the entire freight market. At its core, This case raises a fundamental question the industry has been asking and wrestling with for years. Where does broker responsibility end? And who bears the risk when something goes wrong on the road? Is it the broker? Is it the carrier? Who is at fault and who bears that responsibility? So, make sure you guys subscribe for more news just like this. We will be covering in depth what's going on with the Supreme Court on March 5th, and we will be going through some of those news. So don't forget to subscribe. Go ahead and like this video. It does help us out a ton. It gets us out to other freight individuals just like yourself. And don't forget to think freight.